opportunities that are BJA and SAHMSA drug court specific. The attendee lines will all be muted during this presentation, but feel free to type in any questions in the questions pane on the webinar panel to the right of your screen. We will be able to address your questions during the presentation, or if we can't get to them, during the question and answer session at the end of our presentation. So let's get started. Today's presenters are going to be Jerry Gardner, Executive Director of the Tribal Law and Policy Institute, Lauren Van Schilfgaard, that's myself, I'm the Tribal Law Specialist at the Tribal Law and Policy Institute, and also on the line we have Timothy Jeffries. He is a policy advisor for the Bureau of Justice Assistance at the Office of Justice Programs, and he is the main contact for this particular grant. So if you have any questions during the presentation that you'd like to direct to him, please feel free to do so. To give just a brief overview of our presentation today, we're going to briefly review the CTAS RFP for anyone that wasn't on the webinar yesterday. It'll just be an overview. We'll then dive into two specific RFPs. The first, BJA adult drug courts. We're going to spend the majority of our time on this particular grant, and then we'll also touch upon a grant that SAHMSA is offering. We've also been advised that BJA and SAHMSA are going to soon be releasing a joint RFP for drug courts. That will be released in about a month or so, so keep your eyes peeled for that. We'll then touch upon the Tribal 10 key components and the 7 BJA evidence-based strategies that the adult drug court RFP references. And then we'll finish off with some general grant writing tips. What this webinar will be covering. So like I said, we're going to be covering mostly the 2014 BJA Adult Drug Courts RFP. That's going to be due March 18th, about a month from now. We'll also touch upon the SAHMSA Treatment Courts RFP. This is a new grant that's been released this year. It's due one whole day before BJA. And we'll also be reviewing CTAS. We'll be doing that first, and that's due March 24th. We will not, we'll be providing resources on all of these grants as well as on our website, wellnesscourts.org. You can find links to all of these solicitations. In addition, if you were on yesterday's webinar, or even if you weren't, you can find a copy of the PowerPoint from yesterday's webinar as well as a recording on YouTube of the webinar on wellnesscourts.org. If you go to Wellness Courts and click on either prior event resources or federal funding agencies, you'll find links to the webinar. Today we will not be going into CTAS. That was covered mostly on yesterday's webinar. We also will not be recovering the OJJDP grants that are within CTAS but that offer opportunities for healing to wellness courts. Those are just something to keep on your radar as other possible opportunities. We won't be exploring them in depth today, however. And on this website, that's where you can find more information on CTAS, justice.gov/tribal, and they'll have all sorts of links with resources. Okay, Jerry Gardner is going to briefly review CTAS that we covered in depth yesterday.
Thanks, Lauren. And as Lauren mentioned, that CTAS is covered in much more detail in the webinar that we did yesterday. The PowerPoint slides and the recording itself are also available. But we just want to do just a very quick overview here to kind of contrast with the BJA Adult Drug Court RFP, which is the primary focus here, and just with the general concept of a drug court-specific RFP versus the CTAS opportunity. So first, your first slide here just covers that CTAS, the history of it is its 4th year. The CTAS is an effort to pull together different Justice Department grants for which only tribes are eligible, as opposed to the Adult Drug Court, BJA Adult Drug Court grant, which we're looking at here, and the SAHMSA Treatment Drug Court grants, which are ones in which there's much more general, the states can apply, the state governments and the like can apply, and tribes are just one of the eligible applicants, but not the only applicant, as opposed to CTAS, which is tribal specific. So this slide does indicate that you'll find the information on CTAS at justice.gov/tribal, And the application due date, right around the same time, is March 24th. And the CTAS has been out for, I think it's the maximum period that's allowed, which is the 90 days, basically 90 days that it's been out for. So it came out earlier, but it's due a little bit later than the BJA Adult Drug Court grant is due. So CTAS get opened in December. It closes March 24th. It's important to note, too, that as opposed to the BJA Adult Drug Court and many of the other grants, that the time on March 24th is a little earlier. So keep a close eye on that, and that it's actually due at 7 p.m. Eastern, which, of course, here on the left coast would be 4 p.m., and in Alaska would be 3. So it's earlier in the day than many of the different grants are basically due at midnight Eastern. So keep in mind that CTAS is due a little earlier in the day, and, of course, it's always best to do it much earlier than that day, and certainly earlier in that day, so you don't get hung up at the end and with problems with getting things all uploaded in time. This slide is just a quick overview of the 9 different purpose areas in CTAS. There's 3 areas are highlighted here as the 3 for which you could apply for a wellness court. The BJA Purpose Area 3, which is the Tribal Court Assistance in Indian Alcohol and Substance Abuse Prevention Program, and that's where most of the different wellness courts have, the largest number of wellness courts have been funded over the years. And then Purpose Areas 8 and 9 are purpose areas from OJJDP, the Office of Juvenile Justice and Delinquency Prevention, and it is possible to apply for a juvenile wellness court through those different purpose areas, but there's much more limited funding, especially for Purpose Area 8. The next slide just goes through the basics of what you're required to do for CTAS, the different parts of the selection criteria. There's an overall tribal justice profile, which is 30% of the score, the purpose area narrative, which is 50%, and the template for the purpose area narrative needs to be you need to go online to access that, and it's crucial to have that. The budget, the demographic form, the timeline, and the like. Then also the tribal resolution is required, indirect cost agreement is required, and then you can also submit other attachments such as the resumes, job descriptions for the unfilled positions, letters of support, memorandums of understanding, and those kind of things are not required, but they're certainly good things to do. For CTAS, more information, again, is available at justice.gov/tribal. And the webinar we did yesterday is specific to wellness courts under CTAS, but there's also a wide range of different information through teleconferences and webinars that's broader for CTAS. It's very important to keep in mind with CTAS that not everything you need is in the RFP itself. That the crucial templates for the tribal profile, for the purpose areas, and like are all only available through the justice.gov/tribal website. So that's important to know. These are just slides that give you just a basic overview of the 3 purpose areas in which it's possible to apply for wellness courts. So it's Purpose Area 3, which was the primary focus yesterday, which is BJA Purpose Area, Purpose Areas 8 and 9, which are Tribal Youth Program Purpose Areas. And those are the 3 different CTAS purpose areas for which you could fund a wellness court. The next slide, but won't cover in detail. These just give you some of the pros and cons of applying for a wellness court through CTAS rather than one of the drug court-specific RFPs, which we're going to be focusing on today. One of the big things to keep in mind, a couple of big things, is that some of the pros are you're more likely to have people who are going to know more about tribal courts as peer reviewers. But on the downside, and you don't have to provide, perhaps could be on the pro side, is that you don't have to provide near as much detail in terms of how you're actually going to implement the different key components of a wellness court, because you don't have the time and space to do that in one of those. The cons include the idea that with CTAS, you aren't necessarily going to get peer reviewers who have great deal of knowledge about drug courts or about healing to wellness courts. And so that's one of the downsides to keep in mind. There's many other things that a tribe might want to apply for under Purpose Area 3. And you also might have issues of not as much space to describe the wellness court if the tribe's applying for more than just wellness courts under Purpose Area 3. So those are just a few of the pros and cons of a CTAS-specific proposal for a wellness court. And now we want to shift to the primary focus today, which is the BJA Adult Drug Court RFP. And first, just strongly encourage you to get a hold of, if you haven't, and look and become very familiar with all the details in the RFP itself. And there's a full link is provided here, but as Lauren indicated, it's also available through the various websites, through the wellnesscourts.org. And of course, we've got contact information for Tim. Here, Tim will be able to answer questions today, and then you can contact him later for more questions specific to the Adult Wellness Court RFP. The next couple slides are just basically taken directly from the RFP. It just gives an overview, that background on drug courts, that it requires early, continuous, intense treatment, close judicial supervision, mandatory and random drug testing, community supervision, inadequate, appropriate incentives and sanctions, recovery support, aftercare services. These are all things that you need to make sure that you cover in detail in your proposal. And there, you wouldn't have as much time to do that in the CTAS proposal, but here in the BJA Adult Drug Court RFP, you've got 20 pages to basically lay out your proposal, and so you really are expected to go into much more detail on all of these kinds of issues. The eligibility requirements here are that, and it is identified as the Adult Drug Court RFP, but it also does include driving while intoxicated or driving under the influence of DWI, DUI courts, mental health courts, reentry courts, veterans treatment courts, and tribal healing to wellness courts. And Tim, if you could address here is just the issue of it. The RFP refers to tribal healing to wellness courts, but if you're applying for a wellness court under this RFP, are you limited to doing adult criminal, or is it for wellness courts? It's more broad in the sense that you could be covering juvenile and family wellness courts.
Well, certainly. Under the BJA Adult Drug Court solicitation, the expectation is to service the adults as the identified client. We also provide funding for ancillary services or additional vocational or educational services for other than the adult client, but the adult must be the identified client. I believe it's slightly different for CTAS, and it's more broader or more specific to the family base. But under this solicitation, the adult must be the identified client. Funding.
And then also you can serve only nonviolent offenders, and we'll go through that in more detail as we go through. And also you need to refer to the tribal code to define the legal age of an adult. So Tim, if the tribal code identifies that legal age is 18, or the tribal code identifies as 21, that those are okay just so long as the reference is made to what the tribal code provides?
That is correct.
So you need to make sure that you do in here, that you do in a proposal identify, make a specific citation to how adult is defined in the tribal code. And then there's 25% match required, and we'll go through that in a little bit more detail, but it is an additional requirement here that isn't a requirement for CTAS, and that is explained more on page 12 of the RFP, but we'll also go through here in a slide specific to the match issue. The next slide here, this covers the basic kinds of grants. There actually are 3 kinds of grants that are listed in here overall, which is the statewide grants, but those aren't applicable, so we're not covering those. But they're basically an implementation grant or enhancement grant. The implementation grant is a longer period with a higher maximum, so it can be $350 a year for a 3-year and that's applicable for jurisdictions with a substantial amount of planning completed, but not yet operational. So in this case, the court, where the wellness court would not yet be hearing cases, but it wouldn't be in the very early planning that you need to demonstrate in order to be competitive here. You would need to demonstrate that significant planning substantial planning has already taken place towards developing, or in some cases with tribal courts, it may be resuscitating a tribal healing to wellness court. The enhancement grant is a smaller amount it's only $200,000, maximum $200,000 a year, and it's available for a 24-month period, for 2 years rather than 3 years. But it's really important to note that in order to apply for an enhancement grant, it has to be the court. You have to demonstrate and put and set forth in the proposal that the court has been operational for at least 1 year, and that the court is then planning to expand in one of the areas identified. So expand the number of participants, expand target populations, who have more population than you have, enhance court operations, enhance court and or supervision services, or enhance recovery support services. And with regard to tribal grants, there have been for a number of years about 5 or 6 tribal awards per year under the Adult Drug Court RFP. In fiscal year 2012, though, as DTAP kicked in more, that there's been lesser in more recent years, that there was only 1 tribal award in fiscal 2012, and I think that we don't have it here. There were 3 that were 3 tribal awards in the most recent year, fiscal 2013. Then the next slides go into more detail on both implementation and enhancement. And again, we've kind of covered those, but this is just taken directly from the RFP. It just sets out the kinds of things that can be funded under both, under either an implementation or an enhancement grant. And so you really need to make sure that what you're identifying, what you're proposing to do, is covered under one of, that you're clearly applying for implementation or enhancement, and that you're covering the things that are allowable to be funded under this.
So we just got a question, and I think this might be a nice time to address it now. For healing to wellness courts, must the adults that's coming through this program, must they come to the program through a criminal case, or can there be self-referrals or referrals from social services and other civil type of referrals?
Tim, is that one? Can you address that one?
You might be able to address it better with specifics to tribal arrest. One of the things that I can say that we stress the importance of is that it's a high-risk, high-need population. So the referrals, as long as they're coming from multiple arrests or multiple convictions on substance abuse issues, as evidenced also by having a substance abuse diagnosis, then those are the deeper end clients that we tend to see within drug court funding requests versus misdemeanors or folks that are first-time offenders. Would that be similar on tribal side processing, Jerry?
It would, but I think that the tribal issue comes up a lot in the sense that there, because of the different jurisdictional limitations, especially in the public law 280 jurisdiction and the like, that as a practical matter, the court may not be exercising the full range of criminal actions, but a tribal court could be getting referrals from the state court, criminal court system, for instance, or there are instances in which there's been wellness courts where it's a joint jurisdiction with the state court and the like. So there can be different kinds of situations where the court is basically working in conjunction in some form with the state criminal justice system, where the court is not either have the funding or the ability to currently exercise the full range of criminal actions. So that's what may happen in different tribal court situations. And I would guess Tim, that probably if those kinds of situations are occurring, that there probably would need to be a lot more explanation in the proposal of that, and some and then showing the links to the criminal justice system or to the background in which people, that would be participants in the tribal wellness court would be identified as the high risk and high need. Does that sound okay, Tim?
It does. I agree. I was just in the middle of a thought thinking about how this will relate to the upcoming publication that you have for the 10 key components for tribal and how it relates to those target population components down the line. So that's just a future primer for what's to come on better explaining how we should perceive and do case flow or processing of clients in the system.
Sure, and because I think tribal courts are often in a situation, especially in a public law 280 jurisdiction and the like, where they may not be, the court itself may not be, have the funds and the jurisdiction, the funds and the like to be able to handle the full range of criminal cases, but they may well be handling people who are participants who are high risk and high need and that have been, have been processed through the state criminal justice system. And maybe being handled civilly in the tribal court in some form, but really are people who in the state court would probably be being handled in a criminal context. It's just that tribes have to often do a real patchwork to try and handle, to try and address the needs with the limited resources and services that are available.
Right.
So I think it is important for folks to look at when you're, of course you have to make the determination as you go through, and looking at this RFP, you have to determine, are you going to be eligible for implementation or enhancement? And you might find, for instance, because there really is a gap between, there's the implementation is when you're not yet operational, and then the enhancement requires that you have to have at least a year of operational. So if you are in the in-between, where you've operational but not yet for a year, that you might not be eligible for either this time, but you could look at planning for the future. Because generally this RFP comes out every year, and the implementation and enhancement is generally described and defined in the same sort of way. So if you find that you're in that gap area, for instance, that you might not be eligible this time, but you may be able to be eligible, for the next year. So keep that in mind as you go through. But it really is going to be important that you determine, that you are eligible before you proceed with it for either implementation or enhancement. And there's different sections in various parts of the proposal that deal differently with what you're required to do and to identify if it's an implementation grant versus an enhancement grant. So if we go to there's two different slides on enhancement, and it just kind of goes into more detail of the kinds of things that you would be able to do. And it really is important with enhancement that you're able to focus under one or more of the different bullets that are identified here as the things for enhancement. Go to the next slide. For the priority consideration, here it's important. The RFP mentions specifically that priority is given to applicants who've completed the BJA Drug Court Planning Initiative training. But I think it's really important to keep in mind here that you need to identify that, because the reviewers aren't necessarily going to know that. So that if you have taken part in the BJA Drug Court Planning Initiative training, that you would want to identify that here clearly, so that extra consideration is given. I think there are a couple things to keep in mind. I think it's good to probably, as you're identifying the steps, for instance, if you're applying for an implementation grant, that you would want to identify the different steps that you've taken, the different training that folks have gotten. So if you've gone to the NADCP conference, if you've gone to other kinds of trainings, you could identify those. This specifically refers to the Drug Court Planning Initiative trainings, and that they're, in the past, those have been, that involved an in-person training with a large team from individual tribes, but that's recently in years switched to more of an on-site TA. But I think it's really important to be able to, to give that priority consideration, you really need to identify that. And Tim, this would still count if, say, a tribe had gone through the planning initiative training, say, 3 or 4 years ago.
Right. As long as it's the same team. We kind of envision, it's optimal that they apply, go through the drug court planning training, and then the following year apply, because it's the most recent information that you're learning, the most recent evidence-based tools and integration that you're getting, and it's the same team that's cohesive together when applying. So as long as it's the same team members that went through the training that are still on board with respect to the judge, the prosecutor, public defender, and full team wraparound for the tribe that attended the training, then we would, yes, include that priority for that round.
Great, thanks. And Tim, is there anything in particular people should do? I assume they should probably as you're indicating, it's probably best for them to identify what training they went to, who attended it, and that kind of detail.
It would be, and it's under that, I believe it's that abstract where we ask what year did you attend the training. It would be beneficial to let us know that it was the full team that you have on deck at present that attended the training and what year.
Right, that's good. Rather than just saying generically, we've attended the planning initiative.
Right, right.
Be specific like that.
Exactly. The same thing goes for the letters of support. They generally are better received if you don't just write a letter that says we support the program, but include some detail about how you're supporting the program. If you're a judge and you've had experience with substance abuse treatment components, or if you are a public defender that's experienced different evidence-based treatment protocols, those steps within the letters of support that you're showing tend to show more or carry more weight than just saying, yes, I support the program, or yes, I attended the training.
And having, the letters of support that all are basically identical from each different agency, that the more detail and the more specificity is better.
Right. I mean, that's a really good concept. And keep in mind that we are funding more applications than we've ever funded in the past, and we're still only funding less than half, between 40 and 50% of the applications that come in. So please note it is a very competitive process, and whatever components that you can add to your application that give you a leg up, that allow you to think that you can better answer the question or fully address the question that come before you, then that will improve or increase your chances.
And Tim, and just as a ballpark figure, is that 40 to 50% hold for the tribal applications?
We don't separate the tribal applications in our BJA adult solicitation the way they are isolated under CTAS. We do try to look at geographical diversity and fully inclusiveness, but we don't separate a separate solicitation or a separate pot of funding out of that appropriation that we have for BJA's drug courts. I think this year, and I'm glad you mentioned that because it'll allow me to talk briefly about our appropriation, it went slightly up. So in this day and age, to see any appropriation increases is monumental. But this year, I believe it's about $45 million. So of that, we have a separate set aside. Last year was the first year that we got a specific $4 million for veterans treatment courts. And that's the only unique component that we have that's outside of our regular adult drug court, I guess, bailiwick, if you will. So tribal jurisdictions are certainly eligible to apply under that separate amount of funding, but all of those different funding streams will be collapsed into two solicitations out of the BJA front. One is the one we're discussing now, which is the BJA adult drug court solicitation, and the other one is the joint solicitation that Lauren mentioned that will be released in the next coming weeks or so. So those are the two specific solicitations, once again, that we will be posting, but the only unique area it will be the veterans that will have additional monies for additional Veterans Treatment Court grants. And that does include tribal Veterans Treatment Courts, if there are some of those folks that are on the phone that are interested in applying for tribal Veterans Treatment Courts. One other unique component, because you did kind of allude to this, Jerry, about the enhancement grants, and I just want to expand on the fact that if you are a tribal jurisdiction and you have an operational drug court, that's when you're eligible. You've been operating for longer than a year. You're eligible for enhancing, and you can add a veterans track to your existing drug court and request those enhancement dollars. So that $200,000 pot of funding can go to add or specify services just for veterans within your tribal drug court program.
And so
I didn't
for
know
a veterans court, you wouldn't have to have a totally, you're not setting up a separate court, but just a separate docket for handling of those veterans. And then if folks have questions about the veterans courts, we can get more information. We just send an email to Lauren, and we can get more specific information on that. Tim, while you're talking about the tribal application being part of it, the overall application, is there, you know, because I think it's really important for folks as a peer reviewer, or as looking at peer review, for peer review, the tribal proposals aren't separated, or they're not separated out, so that there's people with tribal wellness court specific knowledge reviewing them. They're just they're reviewed by the general drug court reviewers.
What we've done is, once again in the abstract, if you'll notice when you're applying, we'll ask what type of applicant you are, and we'll give you the choices of the 5 or so that we fund, which is the adult, the DUI/DUI, or DWI/DUI, the tribal, the veterans, and the co-occurring substance abuse and mental health. Those are the 5 different types of categories, and you will put which one you're applying for. We will aggregate all that information and put it on a chart. So what we're looking at when we're funding and making funding opportunities is to see if you meet any of those priority preferences and to what type of court you're applying for. So once again, there's not a separate pot of funding, but we do look individually at which courts that are applying. And to go back and answer your question, when we're looking at the number of tribal applicants to come in, we requested at least one of the 3 peer reviewers has a significant level of experience on dealing with tribal institutions as well as tribal healing the wellness court applications. So once these applicants, the tribal ones I'm referring to, are peer reviewed, if there's 1 or 2 people on the panel that are less familiar with tribal and more familiar with treatment or community organization, there will be an opportunity for one of those peer reviewers to chime in and talk about the components of that application as it relates to tribal lands.
Great. Thank you, Tim. But I think it's really, as we were comparing from yesterday, it's really important to keep in mind the nature of the peer reviewers and so that, just as an illustration, if you're addressing issues with Public Law 280, for instance, that you might be able to, for CTAS, presume that the peer reviewers would know what you're talking about. But here, that it could be that 2 of the 3 peer reviewers might not know what Public Law 280 is. And so I think it's just really important for folks to keep that in mind when you're writing the proposal, is the nature of the peer reviewers that you're writing it for. So that you would need here for this application to not only be providing information specific to your tribe, but you might be able to be required, it might be important to provide more background about tribes generally when you're addressing things, especially if you're looking at the earlier issues we talked about with Public Law 280 limitations and the like, that you would need to provide more background on those issues for the peer reviewers.
And I think that raises an excellent point. When you're looking at one of the most important things that we look at is how well does the problem or the statement of the problem section go to what you're requesting funding for. And I tell everybody that asks or that calls or emails us that no matter what type of jurisdiction or what type of application it's coming in, I personally have an orientation kickoff call with all the peer reviewers and specifically instruct them to look at the statement of the problem and see how well the applicant has addressed the need for the funding to tie directly to that statement. So what you said was just on point with knowing or not assuming that the peer reviewers know your jurisdiction, because they won't. They will see one application that comes in that says that we have a problem in our community with mothers addicted to meth, and it'll be another application right after that that they read that says that the Tribal Healing and Wellness Court is in desperate need of a coordinator. So it's comparing the need expressed well enough in that statement of the problem to how well the funding that you're requesting is going to meet and match that need. So that's a good point that you brought out.
Thanks, Tim. And that really is so crucial in proposal to make that connection, because the tribe could also be, in the statement of the problem, identifying all sorts of other problems, but they need to be problems for which a wellness court is a solution, in essence, that there needs to be a link between the problems you identify and the solution, in this case of a wellness court, that you're proposing to do.
Right, or that's for the implementation, but if it's an enhancement request, it's how well is it that you need to get additional funding to meet the needs that aren't being met currently within your court. So if you desperately need a vocational educational counselor, or you're looking towards more evidence-based treatment integration, or you need funding for more resources, then you would tell us. And it wouldn't be a problem for you to say, we've been operational for 3 or 4 years. These are the components that we have identified as lacking based on an assessment, based on a technical assistance provider's interpretation of our court system. And these are the top priorities that we could benefit in overall improvement of our program and our clients if we get these particular services. So it does kind of like a twofold or two-prong approach.
Great, thanks. And on this slide also is the information that you need to, that the application needs to be consistent with the tribal-specific key components. The reference here is to the 2003 publication that's publicly available. There is a much more detailed draft that's undergoing final BJA review that should be out soon, and some of the actual components themselves that are included in this RFP have been updated around that, but you do need, at this point, to be referring to the currently posted publication.
Right.
The next slide just refers to, as Tim has mentioned, about the evidence-based practices. So it's more information and the like on evidence-based practices and programs and different websites that have information on that. There are, of course, problems with that meeting the standard of what's referred to often as evidence-based programs, that tribal programs have not generally been studied to the extent that they would meet the level of what's expected here. Sometimes tribal applications may have more practice-based evidence and like to be able to demonstrate things, but it's really important to be aware of the evidence-based practices, and where applicable, you could certainly be referencing the general ones as they apply, the general resources available here and the evidence-based practices as they connect to what you're proposing in your wellness court.
Just to add real quick, all of these websites are available in the RFP, and then these slides are going to be posted as soon as we're done with this webinar. So if you can't scribble these complicated URLs down very quickly, you'll be able to access these in both the RFP and on these slides.
And then the next slide refers to the 25% match requirement. And here, it's basically that there must be that what you're requesting here may not cover more than 75% of the total cost. And so in the RFP, there is information on page 12 which provides more detail in terms of how you calculate that. It indicates that can be a combination of cash and in-kind, that no specific amount is required in that, but it can be both. That the match is restricted to the same use of funds as allowed by federal funds. And then it also is important to keep in mind, you really don't, even if you can do it, you don't want to overmatch the 25%, because if, for instance, you say that we're going to cover 50% of the cost, that you weren't required to do that, but if that's what your application says, then you're then bound by that. So you need to keep in mind that there's risks if you were to overmatch the 25%. And then, Tim, I think you may have some things to add here, and I think one of the questions that comes up for tribes is, can 638 funds or tribal self-governance or self-determination funds that a tribe receives from the Department of Interior or even from a different Department of Justice grant, can they be used for the match?
Right, and I believe that was a question that came up before, and what we were told is that we can't augment federal or use federal funds to replace other federal funds. So because the match is a combination of in-kind and cash, from my understanding that there is no minimum cash required match. It just has to be satisfied as a cash match. And then the remaining can be judge's salary, office space, anything that your local jurisdiction funds out of a separate pot of funding can be translated into a dollar amount and equated to the remainder of match.
But could it be from a different federal agency?
I seem to recall some flexibility on that, but my understanding is that the federal dollars cannot be used to match a federal grant. That the 25% must come from the local jurisdiction.
Okay, I think there are issues with tribes around that, because unlike the state systems, tribes often don't have a separate funding source, and the funding often comes from other federal funds. So it presents particular challenges.
Let me get back with you, and then we can put a correction out, because I do remember, and I'm not quite sure what the response was, but I think the question was whether or not BIA funds or other funds that go towards the tribe can be used, and I'm not 100% sure which way we ruled on that.
Yeah, so what I do remember the issue coming up before, and I think that we can certainly provide, Tim, with you more background on that, and then we'll just get back to folks on that. So we'll make sure and send a note once we clarify that to everyone who's on the webinar, and then just put it also on our website.
Thank you.
Thanks. And then we want to shift to performance measures.
So the RFP, this is Lauren, the RFP makes a reference to performance measures, and that awardees are going to be responsible for submitting their performance measures in the form of quarterly reports. You're not required to specify in detail in your application for what these are going to look like, but it's highly advisable that you do. They provide these two separate tools, one for implementation and one for enhancement, through these URLs. This is just a screenshot of one of those performance tools. It's just one page of 18 different pages. And as you can see, they ask various questions about, what's the expected number of participants that you're planning on serving, so that later when you serve a number of participants, we can compare it, how those numbers line up. These are the different categories that those particular tools address. They include your program characteristics, how exactly are you serving these participants, program level measures, the amount of services that you are adding or enhancing because of your grant, participant level measures, how are you serving these participants, such as screening, risk assessment, treatment services, alcohol and substance abuse involvement, so on and so forth. They provide a whole bunch of other tools that are available at this, this URL. Again, all of these tools are meant to assist you in being able to prove that your program is working and that your grant has made a difference. That's sort of the idea behind these performance measures. However, we have these charts that help me better grasp this concept. Oh, so first, this is a screenshot of the logic model that's referenced. And as you can see, they have inputs, activities, outputs, short-term outcomes, and long-term outcomes. And this is a very, very condensed version for processing a lot of information. That we have these goals, we have these big goals, these little goals, these objectives for attempting to achieve those goals, and the actual outputs of what happened there. But like I said, we have these charts that helped me better process what it meant here with an objective such as improve, enhance, and/or expand drug court services to reduce substance abuse and recidivism of drug court participants. That's our goal here. We are trying to lessen the consequences of drug and alcohol abuse in our communities. Well, how are we going to measure that goal? How are we going to define success? We're going to measure that by looking at the percentage of participants that were admitted to the program and the percentage of participants who successfully completed the program. And how are we going to measure that? Well, we're going to look at this particular data that's available and be sure that we collect this amount of data. So these are just examples of ways that you can define your performance measures. These aren't required anywhere, but I found these to be really helpful. So these are just a couple more examples of objectives, how you measure those objectives, and what data you use to achieve that measurement.
And Tim, did you want to add anything more on the performance measures?
No, I think you covered the bulk of what we're trying to do. In addition to that, we just really quickly, we look at these performance measure results, and we also establish a baseline. So we look at where folks are overperforming and where they're underperforming, and then that's what we use each year to do what we call a grant stat, which is an intensive review and overview of every drug court existing grantee that we have. Those ones that are what we consider underperforming, we do outreach, and it's nothing to pull or retract any funding from, but we really just ramp up the intensity of technical assistance and offerings for resources that we have to improve overall service delivery. So if you can just envision that we understand that new programs especially are getting off and they're not exactly sure how to implement, drugs of choice change within the community, the population, arrestee population changes, and I think our intent is to basically work with you through those performance measures analysis to kind of get a better overview of how to provide additional services. So we do work with Jerry, with Tribal Law and Policy Institute, and also Lauren under those technical performance reviews. And those are the folks that we heavily rely on to do outreach on how to do programmatic improvement.
And I think I would just also add here, I think it's important that you identify, your specific target that that you would be doing under, say, an implementation grant. And the trick is to, in some sense, is to have a high enough figure so that your grant is competitive, your grant application is competitive, but not so high that you're not going to be able to meet that goal. So it really is a need to be realistic in terms of what this potential funding and what capacity that you have, and the like. And if your numbers are low, it's important to really explain how and why they may appear to be lower than, say, a major city jurisdiction or something where there's so many more people going through the court. That to be competitive here, you probably often tribes would need to explain the lower numbers in terms of comparison to a major city, for instance.
So again, just to review, these performance measures and the performance tools that I provided in those URLs, those are things that you'll be responsible for after receiving the grant. These are your reporting requirements, but it's worth noting in your application that you're aware that these performance measure tools exist and how you intend to go about successfully measuring your data.
And Tim, the applicant is required to do certain to identify the baseline measures, right?
That's correct.
So in that sense, you do need to identify what you anticipate, what number of participants, for instance, and like this you're going to have. through the wellness court if you're doing implementation, or the additional ones if you're going to be doing enhancement.
And we feel that's only fair. If you're measuring your application and whether or not we provide you funding based on the fact that you say you can service 40 participants in any given year and you're only serving 15, it does us a financial disservice because we could have funded another program that could have yielded a greater number of success or outcome or graduates within the program. So once again, the overall point is not to pull funding back if you're seeing some changes within your populations, but our point is to have you request immediate technical assistance and find out through these quarterly performance checks that, hey, we've identified that we were going to serve 40 clients, but we're only serving 20 or serving 5. How can we get help to get to that maximum number? So that's another good point, Jerry, when you're looking at writing the application, to see what provisions and who is put in place to make sure that you're having an accurate account or accurate record of what your application stated that it would do.
Thanks, Tim. And then if we could shift now to the violent offender prohibition we referred to earlier. There's 2 slides here. The first slide is just laying out what, it's a requirement under here that you can't serve there's a violent offender prohibition. Generally, there's also, at the bottom there's in italics an explanation that it is possible to do, to cover, but you cannot use any federal funds or your matching funds to serve a violent offender. So this is the general rule, the general requirements, and like set out on this slide. The second slide is looking at what the practical implication of that is for a tribal court. And so in doing that, we identified 3 different issues here. First is, of course, looking at the current charges, because you need to look at the current charges and prior convictions. So with current charges, that it prohibits a person who is charged with or convicted of an offense that is punishable by a term of imprisonment exceeding 1 year. Now, because tribes are limited under the Indian Civil Rights Act to being able to only impose, a term of 1 year or fine of $5,000 or both, it would generally mean that it would not apply to any current tribal court charges, with the exception that if the tribe has taken advantage of the enhanced sentencing authority provided under the Tribal Law and Order Act. And so that is the one exception, that a current charge, that if the tribe does have enhanced sentencing and the person could be charged for more than a year, then this part would come into play. Secondly is the prior tribal court convictions, that the violent offender, it only applies to prior convictions for a felony crime of violence involving the use or attempted use of force against a person with the intent to cause death or serious bodily harm. So the reference again to felony, generally a felony is defined as punishable by a term of imprisonment exceeding 1 year. And so in general, again, tribes that have not implemented the enhanced sentencing authority under TLOA would not, the prior tribal court convictions wouldn't count. One other possible exception is that some tribes in tribal code might use the term felony in a way that is different from the general definition of it. So if your tribal code uses the term felony, then they could be considered to apply. And so in both these instances, this is just the technical things of whether or not the violent offender prohibition applies. It still is a best practice generally not to have violent offenders, even if you technically comply here. But because of the Indian Civil Rights Act limitations, that there's limited applicability of the violent offender prohibition. Now, there are different issues with regard to state court convictions. So prior state court convictions could be for felonies. And in general, to ensure that you're not violating this, you should be looking for prior state court conviction records, but tribes have experienced a lot of difficulty in being able to access those kinds of records. But you would need to demonstrate meat of what you really need to put together for the proposal. And so there's different parts of the project abstract, and Tim's referred to this. There's really, it's like basically a 2-page abstract. There's detailed information that you're required to put for it. It's laid out, I think, on pages actually 14 to 16 in great detail. You need to look at each of those bullets and explain, the things on each of them, and to make sure that your abstract covers all of those issues that are requested and required there. Tim, now, the project abstract, can it be longer than 2 pages? Or is it limited? It has to be 1 or 2 pages?
We want it to be as concise and clear as possible. It can be longer than 1 page, and the page limit does not count towards the overall maximum amount of page limit requirements that we have. But just keep in mind, we have 3 peer reviewers that read a panel of 15 applications and score them and rank them in 2 weeks. So the clearer and the easier it is to find, but also, yes, the more inclusive it is in terms of getting the accurate information, the better. So I guess to use your own judgment on that, it would be the best solution that I have for you.
And the abstract isn't scored separately, is it? Is it considered part of the statement of the problem or the project design?
It's part of the statement of the problem and project design. It really is, because it gives them a quick overview of what type of program, puts them in the mindset of okay, so this now is going to be a tribal healing and wellness jurisdiction. I can get a feel for the abstract now that it's a rural community with X number in their population. I can also get a feel whether or not they've had the planning grants. That puts me in the mindset that they've gone through some training. They should know evidence-based components and practices, or that they haven't. So those are the pieces that will help them as they start to read, get a feel for who you are as a jurisdiction. Because keep in mind, they have no idea, most likely, what occurs in your jurisdiction, what the population drug of choice is, what the arrestee population. They have no idea other than that abstract that gets them thinking about how to measure how well you address the needs in your drug court.
Thank you. And then the project abstract, that doesn't count against the 20 pages for the program narrative. It's totally separate, right?
Correct.
Okay. And then the program narrative is 20 pages. It's identified on page 16 of the RFP. It indicates that it should be double-spaced using the standard 12-point font. Times New Roman is preferred with 1-inch margins, shall not exceed the 20 pages, and should be numbered 1 of 20, 2 of 20, and the like. So that's indicated on page 16, and make sure that you follow that kind of information, but then that you do, use it double-spaced and Times New Roman if you can, and the size of the margins. And also, it's really important in keeping with the page numbers and the page limits to PDF the document before you send it, because if you've got a different system than the person pulling it up and you do it as a Word document, your 20 pages may come out very differently. So it's really important to do that. And then in the program narrative, there's the same range of different things in that, and we'll go through that in just a couple slides down. The time task plan is also required. Tim, there's no page limit on the time task plan, is there?
Nope, but just keep in mind that you do have the reviewers that are looking at that, so as clear and concise as possible. But we really like the time task plan to kind of give a roadmap. So just assume you were to get awarded, someone in our office, in our programs branch, will be able to pick up that time task plan, look at whatever month or quarter we're in, and be able to see exactly where you are in progression of your drug court application. So that should flow directly from your business plan, or how you're feeling that your hiring should occur, your increased numbers of capacity should occur, when are you expecting to do site visits or your conferences or any of your trainings that you're scheduling. All of that needs to be clearly and concise, so it's a roadmap that we see in terms of where you are in succession of or progression of your grant.
Great, thanks. But as a grant writer's tip, that keep in mind, because it doesn't have a page limit, you can go into more detail if you run out of space in the narrative. as long as it fits within the overall time task plan. So it is one of those places where if you feel like you haven't been able to adequately explain things, that is one of those ways where you can fit in more detail, but doing it as concisely as possible. The fourth is the budget detail worksheet and budget narrative, and information on that on pages 16 and 17 of the RFP, and be sure to read through all of those. The next slide covers the other documents that are required, the 424, the indirect cost rate agreements, tribal authorizing resolution, letters of support and commitment that Tim talked about earlier. There's also the RFP sets out the state substance abuse director and the chief justice letters, but those are not applicable for tribes, right, Tim?
Correct.
So, but you might, because the peer reviewer might not be familiar with that, you might indicate, because in essence, the tribal authorizing resolution is somewhat in lieu of those. And one of the, I think the state abuse director notation in the RFP references the tribal resolution. But you wouldn't want a peer reviewer to be looking through and trying to find those. You want to make a reference that they're not applicable for tribal applications. Then there's also the applicable disclosure of pending applications, the research, and the accounting system info. The next slide really covers, this is really, really important to look at both in terms of what you devote in the proposal to these different areas and making sure you cover everything. So one of the things you want to look at here is basically 1 through 4 here are all have to be laid out within those 20 pages of the narrative. And so as a general grant writing thing, you say, for instance, the statement of the problem is 20% of an implementation grant. You wouldn't want to spend, so you generally, ballpark, would want to spend 20% of your 20 pages on it. So you would say 4 pages, 4 to 5 pages or something like that on statement of the problem. You wouldn't want to do 10 or 12 or 15 pages on statement of the problem, because then you won't have enough to cover the other issues. So general ballpark is that you want to look at these percentages and spend, within the 20 pages, you want to be in keeping with this. But the other really crucial thing is that you need to look at pages 20 to 27 in the proposal, and it sets out in great detail on these pages under each of these different sections. So it lays out, the percentage attached, but it starts at the bottom of page 20 and continues on all the way to page 27. That you really need to look at these and consider these as a checklist. So every bulleted item that's included on here, you need to address each one of those. Even if you do it briefly, even if you're not totally sure, you need to make an attempt and really try to lay out. So it really is, in essence, the checklist that a peer reviewer will be using to determine whether you addressed all the issues that were required in the proposal. So really, the pages 21 to 27 are crucial, and you need to pay attention to each and every bullet in there as you're going through. It's really, really important. I would add at the bottom of page 27, there's a short section on the budget there, but you would also want to refer back for the more specifics on the budget to pages 16 and 17. So that's included in there. But I think those pages and this selection criteria is just so crucial in how you lay out the proposal and how you address things and how much space you devote to different things. Is there anything you wanted to add to that, Tim?
No, that was pretty good.
Okay, then if we go to, for here, we did, the Macaw Nation has generously offered to share a copy of their successful implementation grant. It's probably not a perfect grant, but it gives you an illustration. It gives you something to go from. And so they've allowed for us to post that, to make that available for other tribes to look at. And so it's just one illustration of a proposal, and it just gives you an idea of what a funded proposal might look like. I wanted to just cover here before we shift to the SAHMSA is really looking again from the flip side at the pros and cons first of if you're trying to decide whether to apply for a wellness court under CTAS or under a drug court specific RFP, especially this BJA adult drug court RFP, that this just gives you some of the pros and cons. That there are things like that you'll have more tribal court knowledge if it's a CTAS, more drug court knowledge if it's a BJA wellness court one. With the BJA drug court RFP here that we're dealing with, there are some additional things like the 25% match, the violent offender prohibition, and those kind of things that you have to keep in mind. The next slide, if you look at no other slide, pay attention to this one. This is really hugely important, is to look at, and Tim's touched on this to begin with some of them, is just the common problems with applications generally here and with tribal applications under the BJA Adult Drug Court RFP. First, the huge one is not providing all the requested information, not looking at pages 21 to 27 and addressing each and every issue there. Not providing the requested information in the relevant section where peer reviewers can easily locate it. So sometimes you may have included it somewhere, but if it's not where the peer reviewer can easily find it, then that could present a problem. One of the things I found sometimes as both a writer and a peer reviewer is that there may be places where there's some section that really is applicable more than one place. And so rather than just assuming the peer reviewer will go back to it, if you're hitting on a bullet, say, in the program design, and you feel like you've already identified it earlier, that just reference the specific page, for more detail, see pages, 11 to 12 of this proposal or something like that, where you're identifying clearly for the peer reviewer that I've addressed this issue previously in the proposal. I'm not going to repeat it again, but I've addressed it elsewhere. So they don't have to glean from it. You're telling them where to look. And the third bullet is what Tim was talking about earlier, is really failing to make the connection between the problems identified in the statement of the problem and the solutions proposed in the program design and implementation. Those really need to be connected together. And you really need to look at those together. It really helps. You can't just write, say, the statement of the problem, then write the program design, and then just go on. You have to be able to take the time to look and make sure that the two line up together. So you want to go back and review the statement of the problem after you've done the program design. Another one is not demonstrating adequate understanding of drug court concepts. That's important. If different writers have written different sections, then that can be inconsistent. You need to make sure you address all 10 key components. And then the next bullet is really crucial, is that you don't want to just indicate we're going to follow these 10 components, but you need to explain how you're going to actually implement and apply those components. So you need the who, what, why, where, when, and how. That you're not saying, well, we're going to comply with this component. You need, in those 20 pages, to identify in more detail how you're going to do that. You need the specific measurable targets for performance measures, and you need to provide adequate sustainability information. That one of my favorite ones which is far too often, is that the grant writer themselves is writing, we have a good grant writer as a sustainability program plan, and that's not adequate. You need more than that, and you need to look at sustainability not just in terms of money, but in a broader sense.
And please note, those peer reviewers can tell if something's written by a grant writer. And I think that's the key thing that we wanted to hone in on before with the letters of support and establishing your support. Even if you are working with a grant writer, it has to have some sort of connectivity and ownership by you as the team members that distinguishes that it's less lip service by someone who's not associated with the jurisdiction as a grant writer, and more in-depth detail and connectedness with the community and willingness to work with the population that you have. That's another good point that we look at in terms of grant writing and standardization of these applications.
And then finally, it's the failure to adequately link the programmatic activities with the budget items. As Tim was indicating, it needs to be, you need to be showing that the budget items directly connect to the programmatic activities. And then finally, if you have submitted before and weren't funded, that you want to make sure that you did get the peer reviewer comments, go back and look at that proposal, look at the comments in conjunction with it. Before we switch to the SAHMSA proposal, were there any, I don't know if we can open up the line to just any general questions about the BJA Adult Drug Court RFP?
Okay, I'll open up the lines, but if nobody's speaking, if you could just mute your phone or your computer. Thanks.
Uh-oh. We can always cover questions afterwards, but before we shifted from the BJA Adult Drug Court RFP, just wanted to provide an opportunity there. So now we'll shift to the SAHMSA.
Yeah, and feel free to type your questions in at any time or email me after the webinar. That's fine too. So we have now reached half point of the webinar. Just kidding. This is a new RFP that just came out from SAHMSA. I'm going to only briefly review it, mostly because we're not terribly familiar with it yet because it's so new. But I highly recommend, if you're interested in this, contacting their Kenneth. Kenneth is the contact person from SAHMSA. So this is a RFP that just came out. It is geared towards juvenile treatment drug courts and then specifically adult tribal healing to wellness courts. So it is a tribal specific. Oh, we have a conference question. Julie, I'll let you finish typing your question as I go through this. The application is due March 17th, so it's coming up quickly. This RFP is available on the SAHMSA website. If you just go to the SAHMSA website and click on grants, it's also available at wellnesscourts.org. This is a, they have $4.5 million, so not huge, but also pretty substantial. They are looking to give 14 awards away, and with it being tribal specific, you know, that's really interesting.
Or tribal inclusive.
Tribal inclusive, at least. It's also, the juvenile portion is open up to tribes and states. You need to be an operational healing to wellness court in order to apply for this. There's no match requirement. Sorry, I'm trying to multitask here. I'm going to go to our questions before we continue on. Julie's asking, if we want to enhance our services by providing a conference on cultural perceptions for community agencies, if we get a meeting space rate, that includes food as a part of the meeting space rate. Can food be provided to conference attendees if we use funds under BJA?
No, they cannot. We cannot use any funding for food or what they consider entertainment, and I do not believe SAHMSA allows funding for food as well.
What if you have a registration fee at your conference?
Registration fees are allowed. Funding requests under our enhancement dollars, and under implementation we usually say that you must budget for one training or conference per year. But as you're pretty much, go ahead.
Could you use the registration fees to pay for the food?
No, because registration fees must pay for the actual program, and most often food is not included anymore at our conferences, so food is usually on your own.
Can providing food or even coffee and things like that, can the cost for that be included in the 25% match?
What you do with the match is not necessarily under our jurisdiction's purview. So that's an item that if you do include it in match, I would put it in there and not count it towards the 25% match. I don't think it's going to be, food will be substantive enough to say that we're matching with X number of dollars for food and beverage.
It's going to be one huge meal. That's a really interesting question. Thank you, Julie.
I wouldn't include it at all in terms of match because food raises a red flag, and there was recent policy changes that said if federal funding is not allowed for a specific item, then they don't encourage match funding to be considered to fund that item as well.
Tim, before we go on, I just had one other question too, was that it doesn't mention, this RFP doesn't specifically reference whether you can or should submit resumes. And there's a reference, I think, on one of the pages to OJP, how you submit them, but there didn't appear to be specific thing as to whether required or allowed.
And you're talking about resumes maybe of treatment providers or resumes specifically for the team members? Which resumes
the team members or the funded positions under the proposal?
It's an option because a lot of times you can be an implementation applicant and you don't even have anybody selected yet. So I guess if you want to provide additional information, just list that as a separate attachment. Label it resumes and put the PDF in the separate attachment after the application.
Great, and that could also include job descriptions for unfilled positions or something like that.
Exactly. And that's a good way to show how fully inclusive you're thinking when you're putting the application together. It's not something that might necessarily will be scored because it won't be a separate line item, but it does go to contribute to the overall score of how well the capabilities and competencies you have, which is I think Section 3, to actually execute this program.
Just to go back briefly to the conference fee food issue, Julie wanted to clarify that rather than going to a conference herself and using BJA funds to travel there, if she hosts a conference and charges registration fees of others, can she use those fees that she's collected from others to serve food?
I don't quite see where the nexus is for our federal funding. If they're hosting a conference and charging registration fees, then we would look at it to say, what is it that you're requesting federal dollars for? Does that make sense? So if you're requesting, let's say, $600 registration fee of each participant, then in essence you paid for the conference, which would include any of your beverage. It would probably include your meeting space and your practitioners to attend.
But if it was...
One of the tips in general, the warnings around the whole conference, the food issue, is that, and just my general sense, I think, in doing it, is that you might get that kind of level of clarity after the award, that you may run, you just be aware that I think if you indicate food in beverage in any way, at least my recommendation, and Tim, see if you would agree with this, is that you should reference specifically that it will be in keeping with the DOJ guidelines on food and beverage. That if you list it in any other way, then you run the risk that a peer reviewer could just look and take a couple points off, which could be crucial for you. So I think it's mentioned food and beverage be very careful in doing that, and if you do, indicate that any use of it would be in keeping with the DOJ guidelines. Does that sound okay, Sam?
Yeah, if you're going to take a stab at it, I would just say what you just mentioned in accordance with the guidelines, but just keep in mind that it will raise a red flag.
Yeah.
And have extra scrutiny. But yeah, that would be a safe.
This is definitely in the same line, but I want to give it a go anyway. Ruth is asking if we provide food for a traditional feast upon, say, a graduation of a drug court participant, would this be allowable use of funds?
And unfortunately and sadly enough, I hate to say it's not, because I recognize the importance of graduations, and something as minimal as a cake and punch in terms of cost is no longer allowable. I mean, we used to allow a modest amount, $200–300 for cake and punch every year, but it's no longer allowable.
But it could be allowable for different expenses that are not specific food, so traditional items, traditional things for the, you know, incentives for the graduates and stuff. That's still allowable, right?
It all is relative to what it is. The food obviously is a huge red flag indicator, but things such as ceremonial coins for a graduate, things like that, as long as it's not considered what they call entertainment, which is now the incentives that we used to allow funding for. So yeah, it's at the discretion of how it's interpreted based on the financial guide, but I think you really hit the point hard, Jerry, when you said it's in accordance with the financial guide.
Yeah, I think if there's any reference to anything related to food or beverage or anything questionable like that, you need to always add that little that phrase, and you can always get clarity after the grant award. But I think you run a risk of any mention of those kinds of things with, you know, you run the risk of losing points from the peer reviewers and it being flagged. But I do think a lot of things with regard to the graduations, like for tribal wellness courts, that you can refer to traditional items or refer to different kinds of things that are required, additional services or traditional, you know, making some references like that. You know, that is something you can kind of explain in that sort of way, because there's going to be different things from tribe to tribe in terms of the things that will have significance for folks based on the individual culture.
Okay, I'm taking over again. I'm gonna screen through these. If you have any particular questions that you'd like to email me about, please feel free. I'm gonna skip through this. The SAHMSA treatment drug court RFP has a lot of similarities with the BJA drug court in the sense they're geared towards these holistic combinations of the criminal justice system and treatment providers. They want to see the use of like 8 different agencies coming together. They want you to comply with the key components, but because this is SAHMSA, there are going to be some differences. They also want to see that you're screening clients for co-occurring mental and substance abuse disorders. They want you to integrate SAHMSA's own definition of recovery, which is provided here. They have numerous different, very specific funding limitations, including the use of federal funds for medical-assisted treatment. I know one tribe, the Swinomish tribe, which is currently using Suboxone as a medical-assisted treatment for heroin addicts. And if they were to apply for a SAHMSA grant, for the SAHMSA treatment drug court grant, they could only use 20% of their funds to fund the purchase of those actual drugs. Here are some other interesting funding limitations. As Tim mentioned, they have a similar limitation on incentives that you provide to clients. I mean, you know, if they have a clean week or a clean month, that you can't provide clients more than $30 in actual cash. This is different than BJA, that you could give, BJA has a limitation on entertainment incentives. Here you can purchase different things, you just can't give hard cash or like a Visa gift card. They have their own performance measure tools that are different than BJA, but a lot of general similarities. And so I have the ellipses at the bottom. These are not all of the questions. These are just examples. And they also have a very, very detailed and long list of required documents. This RFP is very long. It's close to 85 pages. I recommend setting some serious time aside so that you can go through it and give it due attention. Where in BJA you only have 20 pages for the project narrative, SAHMSA is allotting 30. but they have a lot more detailed questions that, like BJA, each point needs to be addressed, even if it's very short. And so while you have 30 more pages, you arguably have 40 more pages of information that you need to squeeze in. So just something to keep in mind. And so these A through I are the different sections that of information that they want to see. And they want it to be organized in these sections. So rather than a 30-page long narrative that all flows together, they want it broken into these different sections.
And they have more limits on attachments. So instead of attaching resumes, they want biographical sketch and those kinds of things.
Yes, they have a detailed list of attachments that they would like to see. And also, unlike BJA, in which the time task plan is open-ended, although Tim did advise that human beings are reading this, so keep it within the reasonable ballpark, SAHMSA does have page limitations on certain attachments. Okay, I want to go back to our question. We have another question asking, are either of these grant opportunities tribal specific, or do they have set-asides for tribes?
I think tribes are eligible, but there's no, and then Tim, if you could elaborate on this, is I think these are grant, both of these are ones in which tribes are an eligible applicant, but there's no separate set-aside
or guarantee
for tribes, and there's no, there could certainly be no tribes funded under either one. It's certainly possible. Tim, do you want to elaborate on that?
I mean, yeah, just as you stated, we don't have a separate line item or pot of funding designated for that benefits every one of the 5 categories we allow our drug court funding to serve. So the only thing that we have a separate line item pot of funding for is for the veterans drug courts.
So CTAS is the only pot of money in which tribes are guaranteed to receive grants.
Because it's only tribes are eligible.
Because
Correct.
Only tribes are eligible. Not the case with these 2 grants. This is a website. It's a clearinghouse for drug court resources. I just wanted to bring it to your attention. It's also referred to in the BJA RFP. So this is where you'll find some of the logic models and those types of fields. I'm not going to spend any time on the 10 key components other than to bring the 7 BJA design features to your attention. Along with the 10 key components, they have under each component one of these design features. You'll definitely see correlation, if not complete overlap. They're just sort of a different way to measure the baseline principles that drug courts should be satisfying when they are serving participants. You'll want to address both of these. And so in the RFP, you can see, for example, the list key component 1, and then these 2 design features that correlate to key component 1. It's just sort of a different way of looking at it. We just want you to be aware that it's out there.
And it's important to really look at pages, the attached Appendix A of the BJA Adult Drug Court RFP, pages 35 and 36, because this lays out the specific, the most recent Tribal Healing to Wellness Court key components, and then the connection to the specific to the different 7 design strategies. And it's important to keep in mind that because they are the key components and the design strategies are explained in the general in the RFP generally, but keep in mind that the tribal ones that you want to refer to, the tribal ones on pages 35 and 36, and that they're different, both in terms of the tribal-specific components, and that there's a slight variation in terms of where the BJA design feature is most applicable under. Now, certainly, under these, they can be applicable to more than one of the key components, but there was an attempt both for drug courts generally and in this case for healing to wellness courts specifically to identify where they are most applicable given each of the components. So when you're referring to those and doing that, you just want to highlight that you want to refer to Appendix A, which is consistent with what's here in the PowerPoint. And then the last section of the slides does go through some general approach to federal grant writing. We've covered many of those going through here, and I noticed that there was a number of the folks who were on the call yesterday, we went through a few more of these in more detail there, but we're not going to go over them in detail here, but just refer you to them.
So the last thing I want to leave you with are the contact information for all of these different grant opportunities. They have made it known that you can email them with any questions, including Tim, who's on our call right now. If you have any questions, if you'd like to, see if you can see other sample successful grants, basically, if you come across any stumbling blocks, feel free to email them. Feel free to email us here at the Tribal Law and Policy Institute. We know that this can be a sort of stressful time as you're pulling together all of these different resources, but we applaud you for the immense effort that goes into these.
I guess it's just if we have a final opportunity for any additional questions people want to raise or anything additional, Tim, that you wanted to add?
No, that's it. The only other one important thing I want you to note is that please look at submitting your applications early. If you're going to consider for the Bureau of Justice Assistance application, look at it more than a week in advance. Give yourself more than 5 days to get all of the numbers and the information that you need to upload your application. They're very strict on that. If there's no DUNS number and things that you don't have, the SAM identification number, all those things in the pre-application phase, we will not extend or open your grant. I can't stress that enough, and every single year people contact me after the grant is over and closed and say that they really spent all night working on an application. It's a really good, solid application, and they could not get it into the system. And every year we've had to deny at least 5 to 10 quality applicants because they did not get their application in time for the deadline. So it's just not something where you can submit 24 hours before and have everything you need. This is something you need to get your SAM registration information together. This is something you need to get your DUNS number correct for your jurisdiction, and everything that's required of you in the writing and the narrative of the solicitation at least 5 days before. That way you still have 2 to 3 days to upload. As you can imagine, on the East Coast we've had these crazy weather storms, power outages. If those things occur, there's certain circumstances that will prevent you from possibly uploading. So you want to err on the side of caution and make sure that you've taken care of everything in case something like a power outage or something like that occurs. And that's it. I did want to congratulate TLPI, Lauren and Jerry. You've done a really remarkable job. I feel that you fully addressed all of the differences between the BJA and the SAHMSA and also the CTAS solicitations. I think you've given them, the applicants, a very good understanding of what we're expecting, and I hope on the BJA front have been able to let you know what we instruct our peer reviewers to look at. If you've taken some of this in and like Lauren said, have additional questions in the next week or two, feel free to shoot them to either TLPI or to me or our Justice Information Center. They're the ones listed on the application. Thank you. I think we're over time, so I'm sorry I was long-winded, but I hope and think you guys will be on a good start to processing some really good applications.
I wanted to just throw out real quick, I also included this fiscal year 2014 SAHMSA Circles of Care RFP. This is not Healing to Wellness Court specific, so I didn't talk about it at all. But it is Indian specific. It provides grant opportunities if you're instituting any mental health care. I just wanted to highlight that it's out there. And then finally, Steve had a comment of competition for a small tribe like ours, and I think that's valid.
Yeah, it is a challenge, and it's important to keep in mind the distinctions between and make the decision on the CTAS versus the adult drug court RFP. That it is a lot to do, and really your proposals are very different for the two different applications.
But with that, Tim is absolutely right. We're over time. I would like to thank you all very much for sticking it out with us, including if you were with us yesterday. These slides I'm going to put up now on wellnesscourts.org, and then the recording should be available sometime late this afternoon, tomorrow morning, and I'll put that out on wellnesscourt.org. If you're having trouble finding it on the website, feel free to email me. I'm at lauren@tlpi.org. Thank you all very much.
Thank you, and we're over time though. GMS would have cut us off by now.
Yeah.
Thanks, everyone.
Take care.